Okay, so I guess now you should be. Okay, guys, can you hear me? Has the live started? Can you guys hear me? Just let me know if I am audible. Okay, I am audible. Now is the voice okay? Now, Vinayak, please just update me. Is the voice okay now? The voice is okay? Or is there still echo? Ah, good. It's getting worried now. Then if I have to do that again, I am just so done. Okay. So okay, fine. So I basically wanted to discuss with you today doctrines, not too much in details, obviously, just the basic introduction about doctrines. What is it? And also the questions of those. Okay. So we'll start with the whole concept of doctrine. So the first of all, the word doctrines actually means what? It means principles, right? The word doctrines actually, don't tell me. Seriously, don't tell me. This is not working. Anyway, so the word doctrines actually means principles or rules. So, first of all, the first doctrine, which is doctrine of ultra vires. Ultra vires means beyond the powers. We all already know that the MOA of a company gives us certain powers, and this is the ambit within which the company or the board of directors can work. And if they do any contract which falls outside this, so basically, it is like a safety circle, or whatever name you call it safety circle, you call it whatever, it is like that. If you do anything which is within that circle, it's fine, but the moment you step out of that circle and you do anything, that is void, and that is known as ultra wires. When we say ultra wires, for what you thanking me? I mean, the creator to world. My God, seriously, you guys do have such amazing names. So I don't know the names, so I have to use such names. But for what? Thank you. Anyway, I was planning to do the first link did not work, so I had to make another one. Anyway, so as I said, doctrine of ultra wires. Now we already know there is a clause called the object clause in the MOA. Anything within this clause is within the powers of the company. It is intra wires. Intra means what? Within. Powers means what? Wires means what? Powers. When it is within the powers, obviously it is valid. But if you do anything which is outside the scope of the company, outside the powers of the company, it is ultra wires. Ultra is obviously outside or beyond. Wires is powers, and hence it is void. Now, when we say ultra wires is not just ultra wires the MOA, it can be ultra wires the act, it can be ultra wires the MOA, and it can be ultra wires the AOA, right? It can be ultra wires the MOA, or ultra wires the AOA, or ultra wires the act. When it is ultra wires the act, obviously it's also illegal. Ultra wires the MOA, it is void, and ultra wires the AOA is void, but it can be ratified. I'll give you a very simple example. I'll give you a very simple example for the concept of ultra vires. We had discussed this case in the class also. So you wanted 500 rupees from your dad, and you go to your dad and you tell him, Dad, I want money. He says, go, it's there in my pocket, take it. Now there are three 500, and obviously a human, I mean, as a human, you obviously will get a little tempted, and your brain says one, your heart says, nahi bacha, do to le le. Brain and heart have a fight. Finally, you end up taking one, nahi, two 500. Okay? Oh, Ritesh, that's so sweet. So, you take two 500. So, one 500 was within your power, two 500 was outside your powers. And when the company does anything, so similarly, it was outside your powers. And when you do anything which is outside your powers, such a contract is void. So similarly, when the company, and this concept was laid down in the case of Ashbury Railway Company versus Ritchie, and what happened in this case was that Ritchie approaches Ashbury Railway Company to give Ritchie a loan. Now, the MOA of the company said that the company could sell, lease, or otherwise give on hire railway carriages, or to carry the work of mechanical engineers or general contractors. Now, company agreed to give loan to Ritchie, and then later they realized they're not allowed to give the loan. So company calls Ritchie and they're like, bro, we are not supposed to give the loan. We shouldn't have given you the loan. We are so sorry. The contract is void. Ritchie says, look, your MOA says general contractors. So as a general contractor, you actually are eligible to give me the loan. He says, no, bro, I don't know whether allowed or not allowed. My MOA does not say anywhere I can give loan. I cannot give you the loan. Ritchie's like, no, bro, see, it's given, you can give. They have a like, no, I cannot. He says, you should. He cannot, should, cannot, should. Finally, Ritchie says, okay, I'll take you to the court. Company is like, do whatever you want, but I cannot give you the loan. So the case goes to the court. And in this case, the court applied the rule of egisdem generis. That is, when specific words are followed by general words, the general word will get its color from the specific words. So there was one word, mechanical engineers, and there was another word, general contractors. The word general contractor will get its color from mechanical engineer, and it means anything to do with mechanical engineering, and giving loan is not included. So the court held it's void ab initio because it's ultra vires. So first thing, anything which is ultra vires, the MOA is void ab initio. Either of the parties cannot sue each other. That is, neither Ritchie can sue the company nor company can sue the third party. That is Ritchie. Third, now let's say, now when you have taken two 500 instead of one, your dad comes to know, two things can happen. And let me tell you, the first thing will never happen. He says, it's okay, beta, I'm earning for you. So tomorrow you would have got the money. I'm giving you today only. So this is just a myth. And please do not try these tricks at home saying that, oh, ma'am ne bola tha, this will happen, so let me do it. No. So reality is what I'm going to tell you now. Right? Reality is what I'm going to tell you now. So what will actually happen is you will get flying chappals. You take authority, you take money, fine. You don't take authority, you take money, not fine. So even the whole body of shareholders cannot ratify it. See, the concept is, first alter your MOA and then contract. This is fine. But what you are trying to do is, you are trying to make a contract and then you are trying to alter your MOA. This is not fine. You cannot ratify it, right? So it cannot be ratified. Now, so if tomorrow any liability arises in such a case, who is liable? The directors are personally liable. Company is not allowed to do something, but the company is doing it. So where in a contract there is a negative clause and one of the parties breaches the negative clause, can we sue the other party to stop them? Yes. This is known as what? Injunction. So here, even a single shareholder, irrespective of whatever number of shares he's holding, even a single shareholder can go and sue the company. Right? Even a single shareholder can go and sue the company that you are not supposed to do, you are doing, I'm stopping you from doing it. So even a single shareholder can sue the company for injunction. Now, last, if it is ultra vires the directors, but intra vires the company or the shareholders, right? But intra vires the company or the shareholders, then it can be ratified. That means company is allowed to do it. Directors are allowed to do it, but only with the consent of company. When I say consent of company means consent of shareholders. Then if the shareholders want, they can ratify the act. Now the whole question that arises, ma'am, how will Richie know whether the company is allowed to do or not? If you say directors of the company know, no, that's fine. That's absolutely fine, because they are the part of the management of the company and they should know about it, because they have read that they have access to MOA. But Richie, a third party, how would he know what is given in the MOA? So comes the next doctrine, which says that whenever a company files its documents, files its any documents for that matter, most of these documents, some are not accessible, that's a different thing, but most of the documents become what? Public document. And you just have to go and pay the fees to the ROC, and ROC will give you access to the documents. Under section 399, it becomes a public document, and it is deemed that every person dealing with the company knows about it. That means I'm not going to ask Richie, hey Richie, did you read my MOA? You have come to contract with me. No, you have come to contract with me. Obviously, you have read my MOA, story end. So you have come to contract with me, you know about the MOA. So even Richie cannot say, Ayo, I don't know. Because you are coming to contract with me, it is your duty that you should read my MOA, know about it, and then come and contract with me. So this is doctrine of constructive notice. Whenever a document is filed with the ROC, it becomes a public document, and it is deemed that every person dealing with the company knows about it. This is known as I said, doctrine of constructive notice, and this doctrine gives a protection to the company against the outsiders. Clear? Gives a protection to the company against the outsiders. Now, fine, I understand as an outsider, I am supposed to know about the rules. But can an outsider know about the internal management? No. How is that possible? Imagine, let's say every family has rules. You all must also have some rules. Your dad, your mom, your parents must have put up some rules specifically that you have to follow them. So let's say one of your friend, he comes to your house. Now your family has a rule that whenever you eat, you have to go and keep your utensils, your used crockery in the sink. That's a rule. And the punishment if you fail to do so, in some houses, ma'am, it's there in general, yes, it's there in generally almost all the houses, but some houses they don't have it also. So your family has this rule that the moment you have had your food, you have to keep your utensils, your crockery, whatever you have used into the sink. And if you fail to do so, the punishment is you are supposed to wash the entire utensils of the house that day. Now your friend comes to your house to eat, and he ate. Very smartly, he kept the plate there on the table. And now you are looking at your mom. This guy is going to get a good one in your mind. Friends ke saath na, I will have fun. Take pictures, put it on Snapchat, send it as a streak to everyone. Today's streak done. Correct. Happens, no? Right. So, you are waiting happily, but mom is not saying anything to him. You're like very irritated, ma'am. Mom, how can you do that? Right? Mom, how can she do that? And on the other hand, she's telling you, listen, you also pick up his plate and keep it in the sink. Like, what the hell? Not just giving any punishment, she's asking me to put her. Oh my god, you are so pissed off. Now, do you think your mom was right in not punishing him? Do you think your mom was right? Obviously, she was absolutely right, because as an outsider, he wouldn't know about the internal management. Similarly, when an outsider is, let's say, company is allowed to do something, but consent of shareholders have to be taken. Right? Now, as an outsider, I am supposed to check whether the company is allowed to do or not. If I get the answer as yes, my concern is over then and there. After that, I am not required to check how the consent was given, what they did, what they did not do. All that is not my concern at all. So, as an outsider, it is my duty to check whether the company has a right to do something or not. How the company got is not my concern. How the company got the consent is not my concern. I hope it's clear to everyone. So comes the next case, the Royal British Bank versus Turquoise, or simply the Turquoise rule. Right? The Royal British Bank versus Turquoise rule. So what happened in this case was the bank was allowed to issue bonds. Right? The bank was allowed to issue bonds, but up to a certain limit. Beyond that limit, they have to get the consent of the shareholders. Beyond a certain, so if they were issuing bonds of up to, what do you say, 200 pounds, they were allowed to do. But if it was more than 200 pounds, they need the consent of the shareholders. They issued bonds of 2000 pounds, but consent of the shareholders was not taken. Then later, when the outsider asked them to cash the money, they refused to pay. As an outsider, I just have to check whether the company is allowed to issue the bonds or not. How the company gets the the right to issue is not my concern. So here, can the bank refuse to pay? No, the bank is liable to pay, because as an outsider, my duty is only to see whether the bank has a right to issue or not. How the right was given to the bank is not my concern. So this was the next doctrine, which is known as doctrine of indoor management, and this actually protects the company. Protects the outsiders against the company. So you can actually say this is like, a locha to the doctrine of constructive notice. But people started misusing it, and because of that, people started misusing this doctrine, and they tried to, evade. They used to do wrong things and try to evade the punishment for that, or they claimed rights in spite of the fact that they did not have, on the grounds of indoor management. So the lawmakers, the court, in different cases laid down some lochas where the doctrine of indoor management will not apply. The first one is knowledge of irregularity. Now your mom did not punish your friend. The very next day, what you do is you leave your plate, and now you are very happy. Happily you go into your room. Your mom, hey, come here, take today your duty to wash. Like, why should I wash? Yesterday my friend did not do, but you never told him. But today you are telling me, why should I wash? She's like, he did not know the rules. You are a part of this family. Rules are rules. Oh, chalo, move, get to work. Can she actually punish you? Yes. Because as an outsider, your friend does not know. But you are an insider to the house. You already know about the rules, so you cannot claim any relief. So, this rule does not apply in case where the person knows about some wrong, that is, he knows something is missing, or where the person was negligent, or in case of forgery. You remember, all of you, Hasina Bano? Yes. Or the last one, in case you have no knowledge. Ayo, I don't know MOA. Leave me this time. Next time I will read and come. Next time we will see. No knowledge of MOA and AOA. I hope this is clear. If anyone has any doubt before we proceed to the questions, you can ask me. And thank you so much, Ritesh, for your kind words. Chalo, now anyone has any doubts before we move forward? Ask me. We will discuss the doubts and then we will move forward to the next topic. I hope you guys are there with me, huh? I'll only discuss the doctrine questions, not the questions of types of company. I'll not discuss what is capital, what is memorandum, all those questions I'm not going to discuss. Only the questions relating to doctrines I'll discuss today. Is it that this stream stopped sometime because no one is answering anything? Or doctrines was such a heavy topic that again you are lost? No doubts. Nice. I am expecting amazing results from you guys. I mean, the paper should be like, oh my god, ma'am, too good, like that kinds. So I will just discuss the questions here. So from here, questions, doctrine questions actually start. So let's discuss this. The articles of XYZ Limited provides that DOD has authority to issue bonds provided such issue is authorized by the shareholders by a necessary resolution in the general meeting. The company was in dire need of funds and therefore it issued the bonds to Mr. X without passing any such resolution in general meeting. Can Mr. X recover the money from the company? Can we say this is the same question as what you say, the case Royal British Bank versus Turquoise, right? So can Mr. X, as an outsider, it is his duty to check whether the company has a right to issue the bonds or not. How the right to issue was given, that is not his concern, right? So as an outsider, can he recover the money back? Yes. As an outsider, he is not concerned about the internal management. It was just his duty to know whether the company has a right to do a particular act or not. AK Private Limited has borrowed 36 crores from BK Finance Limited. However, as per MOA, the maximum borrowing power of the company is 30 crores. Examine whether is liable to pay the debt. So obviously it's ultra wires. Now there are two ways of looking at this answer. You can either completely say it's void, or you can say to the extent it is allowed, that much can be recovered, or to the other extent, that is the extra, for that it is void. I'm not going into the direct questions, no point in doing that. I just explained the doctrine of ultra vires, so you just have to write that only. Mr. X had purchased some goods from Messrs. ABC Limited on credit. A credit period of 1 month was allowed to Mr. X. Before the due date, Mr. X went to the company and wanted to repay the amount due from him. He found only Mr. Z there, who was the factory supervisor of the company. Mr. Z told Mr. X that the accountant and the cashier were on leave. He is in charge of receiving money and he may pay the amount to him. Mr. Z issued a money receipt under his signature. After 2 months, Messrs. Limited issued a notice to Mr. X for non-payment of the dues within the stipulated period. Mr. X informed the company that he had already cleared the dues and he is no more responsible for the same. He also contended that Mr. Z is an employee of the company whom he had made the payment, and being an outsider, he trusted the words of Mr. Z as duty distribution is a job of the internal management of the company. Whether Mr. X is free from liability? Yes. As an outsider, this guy was a factory supervisor. He was an officer of the company. He told him that the cashier were on leave and the accountant was on leave and he was in charge, and he also gave a signed money receipt. So as far as X is concerned, he has already paid. As far as X is concerned, he has already paid. And if he has already paid, his liability is obviously over. This is lifting of corporate wheels, so I'm not going into this. Ravi Private Limited has borrowed 5 crores from Mudra Finance. This debt is ultra wires to the company. Whether the company is liable. Again, same. Obviously, companies are allowed to borrow funds. There just could be one thing, that there could be a limit. Here, 5 crores was borrowed. Whatever was the limit, that much is intra wires. For the rest of it, it is ultra wires. 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 It is ultra wires This is again a direct question, so I'm not going into this. Articles of provides that BOD can take a loan of up to 50 lakh for the company by passing the board resolution. In case where the loan amount is in excess of the said limit, special resolution is required to be passed in the general meeting. Due to urgent need, board applied for a loan in a reputed bank for 60 lakh without passing the special resolution. Board of directors gave an undertaking to the bank that the special resolution has been passed. The bank, on believing, lent the money. On demanding the repayment of the loan, the company denied the payment of as the act was ultra vires. When first of all, I just have to see whether the company has a right to take the loan or not. How the loan was given is not my concern. Secondly, they also gave an undertaking to the bank that yes, we have passed a special resolution. So I am not running here an investigating agency. I'm not Sherlock Holmes here. I'm not going to go and search through the papers with a microscope. Oh my God, is the resolution passed? Not my concern. Bank will get the entire money back. Doctrine of indoor management. As an outsider, it's not my duty to check whether the bank has a right. I mean, how the company got the right. The company has a right. That's it. If I have given a loan, the company is liable to pay. Actually, the past two questions, they are all again lifting of corporate wheel. This is also lifting of corporate wheel. The object clause authorizes the company to carry on the business of trading in fruits and vegetables. The directors of the company recently concluded board meeting decided, and accordingly the company ordered for fish. Wow. For the purpose of the fruits and vegetables and fish. They supplied fish worth 36 lakhs. The members of the company convened an extraordinary general meeting and negated the proposal of the board on the ground of Ultra Vires Act. Seeks your advice. Advise them. Nothing. First of all, the company was only allowed to enter into contracts of fruits and vegetables. They agreed to buy fish. Khatam. Ma'am, outsiders, though, they should get a relief, no? Outsiders should have knowledge about the MOA. It's a public document, so they cannot claim any relief. So, the company is not liable. The contract is absolutely void. The Articles of Association of Avenue International Private Limited contained a clause that in case of insolvency of any member, his shares in the company should be sold to other person at a price fixed by the directors of the company. Mr. Neeraj, a shareholder, was adjudicated insolvent. His official assignees in insolvency claimed that he was not bound by the provisions of AOA and is free to sell the shares at the true value. Whatever is given in the AOA, it is binding on the company and the members. There is a contract between the company and the members as if they have individually signed it. And whatever is given in the articles is binding on the member if it is given in the capacity of a member. So here, this is a duty in the capacity of a member. So whatever is given is binding on the member and they are liable to sell the official assignee is bound by whatever is given. That is, they are liable to sell at the price given by the company. ABC Limited was into sale and purchase of iron rods. This was the main object of the company mentioned in the MOA. The company entered into a contract for some finance related work. Again, company is in the purchase and sale of iron rods and the company is making a contract for finance. Obviously, it's outside the scope. Later on, the company repudiated the contract as being ultra vires. Can the company do so? Yes, the contract is ultra vires because it's outside the purview of the company's objects. Oops. So, this is a direct question. Okay, so basically this is about incorporation, false information and incorporation. Since we are doing doctrines, I'm not going to go into this. Sound Syndicate Limited, a public company, its articles of association empowers the managing agent. Now, when I say managing agent, can I even call the directors as managing agent of the company? Yes, the directors are the managing agents of the company to borrow both short and long-term loans on behalf of the company. Mr. Little, the director of the company, approached Easy Finance Limited, a non-banking finance company, for a loan of 25 lakh. Mr. Little, who is the director of the company, approached Easy Finance Limited, a non-banking finance company, for a loan of 25,000 in the name of the company. The lender, does he have a right to borrow? Yes, because it's given managing agents can borrow both long and short-term loans. The lender agreed and provided the above said loan. Later on, Sound Syndicate Limited refused to repay the money borrowed on the pretext that no resolution authorizing such loan has been actually passed by the company, and the lender should have inquired about the same prior providing such loan, and hence company is not. Since your article gives the power to the directors to managing agents to take the loan, they don't have to take the consent of the company. So when the company makes this claim that because we have not given the consent to the director, the loan was not valid, is not justified, because the articles is already giving the power to the directors or the managing agents, and director is a managing agent. So company is bound by this contract. So contention of the company is not correct and they are liable to repay the money back. R, a manufacturer of toys, approached MNO Private Limited for supply of raw material. Oh, this is the same question we just did. Mr. R was offered a credit period of 1 month. Mr. R went to the company prior to the due date and met Mr. C, an employee at the billing counter, who convinced the former that the payment can be made to him, as the billing cashier is on leave. Mr. R paid the money and he was issued a signed and sealed receipt by Mr. C. After the lapse of due date, Mr. R received a recovery notice from the company for the payment of 1,50,000. Mr. R informed the company that he is already paid and had the above amount, and being an outsider had genuine reasons to trust Mr. C, who claimed to be an employee, and issued him a receipt also. Discuss the fate of this. The company filed a suit against Mr. R for non-payment. They cannot. Discuss the fate of the suit and the liability of Mr. R towards the company. No liability. He has already paid. And since he was even issued a receipt, it is on behalf of the company. He is not liable. Would your answer be different if if a receipt under the company's seal was not issued? Yes. Then Mr. R would be liable. Why? Because there is no authentication from the part of the company that the payment has been received. So there is no authentication here, and in that case, he would obviously be liable. See, if a receipt was not issued, Mr. R is liable to pay the amount, as this will be deemed to be a negligence on the part of Mr. R, that he just paid the money to just about anyone without having reasons to believe that the person has a right to receive the money. And with this, we are done with all the questions of doctrines. Before I end the session, I hope this helped you. Before I end the session, I also want you to tell me, like after tomorrow, I won't be available for a week. So only tomorrow I can take live classes. I'll take it during the day, not evening. So if you want any specific topic that you want me to take live classes on, please just drop a message in the group. I will accordingly, arrange classes for tomorrow. After this, I'll be available only on 31st December. I mean, I'll be available on messages, but not on video. I mean, on live, YouTube live. So if you want me to take any specific classes, do let me know about that. Okay? It will be done tomorrow during the daytime. And keep studying. And keep studying. Okay. Okay. That's good. Shabazz, how are you? How is studies? Hey, you just wrote your intern, no? If I'm not wrong, Shinchan. Should actually call you Shinchan only. Huh? Chalo, I'll see you all again tomorrow. If you have any your specific videos. How was it? How was the exam? How did your paper go? This attempt was really easy. It went good. That's good. I just hope the same for the foundation students also, that they tell me that their paper went amazing. Chalo. Bye bye. Shinchan, take care. Bye bye all of you. Keep studying. Keep taking breaks also in between. Keep doing things that you want to do in between, so that you come back with more energy to study. All the best. I'll see you all tomorrow. Bye bye. Bye bye. Bye bye. Bye bye. Bye bye.